A very good afternoon, everyone. Now, the focus of my speech is going to be on the question as to whether Malaysia has set a new human rights standard for Singapore, basically from what we see from the outcome of the Malaysian elections. Now, in order to address this issue, I will look into some of the laws as well as the institutional reforms that are taking place in Malaysia. Now, the first thing that comes to my mind is what the Attorney General of Malaysia said in his video in Mr. Tommy Thomas. I'm sure many of you would have watched that speech. That Singapore has no constitution, we have no constitutional lawyers, we have no constitutional court, and that the Malaysian lawyers don't look at Singapore decisions when they are looking for constitutional cases, and that Malaysia is 100 times better than the Kiasu land. That's what he said. Now, he said this in 2009. In 2009, Malaysia was already saddled with so many problems, and under Najib's authoritarian government, that this statement was uttered. That speech was made in 2009. Can you imagine how much ahead is Malaysia in terms of its track record, in terms of human rights and constitutional legal standards? Whether I agree with this, of course I will quite agree with this statement, although I have some exceptions about what he has said. Now, in essence, what Tommy Thomas is saying, and I'm beginning my speech with this because we have to deal with the perception. Lim Tian talked about the freedom of speech, but that emanates from the Constitution. So every other stuff that we are talking about in terms of the human rights, we have to reflect our own Constitution. And what Mr. Thomas, in essence, is saying is that we have no respect for the Constitution. As a constitutional lawyer who had done several landmark cases in the recent past, I would agree that we have no respect for the Constitution. I give you one example. The extent in which we not only have no respect for our Constitution, but we desecrate, we mutilate, and we defile. And we see one instance of that, of course many instances, and you can see the desecration of that in the ISA case. When Teo Solang and the rest of them were released by the court after a court battle, Parliament passed a legislation not only to change the law, but they changed the Constitution to exclude the judiciary from exercising their powers to address the injustice that was faced by these ISA detainees. In other words, what they have done is that they have gone, you can amend the laws, but not amend the Constitution and amend it in such a way that those litigants who are seeking their constitutional protection, and the courts are there to grant the constitutional protection, but you tie the court up with the constitutional amendment, blindfold the Constitution is our mother, blindfold her so that she can't see the violations. And this is something which is unthinkable, unimaginable in any part of the world. In any part of even authoritarian Commonwealth, part of the Commonwealth, this has not taken place. But this has taken place in Singapore, and it continues to take place in Singapore. Now, I would, when the Malaysian Attorney General said that we have no constitution, there is another Attorney General of another country who said the same thing, that we have no constitution. Would you like to make a guess from which country he comes from? It's actually the Singapore Attorney General. Professor Walter Woon, who was the then Attorney General of Singapore, in 1991 said that Singapore has no constitution. Why we have no constitution? Because we constantly amend the Constitution with such inflexibility, it no longer retains the characteristic and efficacy of a constitution. Yes, we amend the Constitution as if we change the Constitution as if we are changing underwears. And so the sanctity of the Constitution is lost. Now, I will say that despite all this, to be fair to our courts, in the years 2009 onwards, so especially from that period, the then Court of Appeal judges, Justices Chan Sek-yong and Justice V.K. Raja, they raised the constitutional discourse to a very high level, to be fair to them, despite all the limitations. I would say that, and in fact, the Malaysian lawyers, in fact, cited the case of Yong Wee Kong versus the Attorney General, a case which I argued, in support of the Anwar's case, when it involved a question of pardon. I found out that when I was speaking to Anwar's lawyers. So, they raised this constitutional discourse to a very high level. Unfortunately, Justice V.K. Raja is no longer in the bench, and his absence from the bench is a colossal loss to the nation. And I hope that one day he returns to the bench. Now, the next topic I would like to touch is on the question of key reforms that we can emulate from Malaysia is taking place in the area of the Attorney General's office, also in the area of the judiciary. Now, Mr. Tommy Thomas himself has mooted the idea that the AG's office should be decoupled. Currently, just like in Singapore, the AG's office is also the public prosecutor's office. As you know, the AG is the legal advisor of the government, and the public prosecutor is the custodian of the public trust on prosecutions. And now there's a move to decouple them. Now there's another change which I believe we will be seeing it because it is in the Pakatan 60 Promises, which is to remove the role of the Prime Minister from the selection, appointment and promotion of judges. And in fact, that bodes well for the separation of powers, and in fact, it also strengthens the independence of the judiciary. In fact, most Commonwealth countries have moved away from this colonial practice. It was in colonial England that they started this practice. And it is only time, I hope, that Singapore will move away from this allowing the Prime Minister to appoint the judges, because it is not appropriate for the Prime Minister to appoint the judges, and they should be appointed at his pleasure. Now, the next observation the next observation that I make on the Malaysian elections is in the area of multiracial representation in Parliament. Now, the Malaysian results show that people don't vote on racial lines, that they don't vote their leaders based on the skin color of their leaders. And this, in fact, I would think that Singaporeans are no different from them. And we had always voted on non-racial lines until the GRC was introduced in 1988. In fact, the Malaysian elections turns the rationale of the GRC on its head and make us reflect, do we need the GRC? You and I know, GRC was used as an excuse to manipulate the electoral system so that it stifles political competition, it fortifies the incumbents, and it works against democracy. And you know what is worse? Talking about, again, mutilating our constitution. We don't, the GRC concept has also undermined the one-man, one-vote system. We don't have the one-man, one-vote system anymore. How can you have in one constituency when the voters can elect 4 to 6 MPs, and in another constituency when the voter can only vote one candidate? There's inequality of there's disparity in the weight of the vote, and that breaches the constitution. The equality provision of the constitution is breached because one voter is more powerful than another. In fact, the government, knowing that it is in breach of the constitution, went again on their Kiasu mission to amend the constitution by excluding any constitutional challenge. In fact, they amended Article 39 of the constitution to exclude any constitutional challenge on ground of inequality. And again, this is what I mean. You again exclude the judicial powers for citizens to exercise their rights before the court, and you exclude judicial powers and prevent the courts from reviewing such matters. Now, what the elections in essence, the Malaysian elections in essence show, that you don't have to tinker with the one-man, one-vote system. All you need is to allow democracy, the conditions of democracy to flourish. It will end the forces of natural selection, will make sure that the ecosystem is preserved with diversity of representation brought in parliament. It's as simple as that. Here we micromanage everything, and for the wrong reasons, and that is what is very sad. Now, the next I would like to touch is on this issue that the Malaysian elections have dispelled once and for all the myth of the dichotomy of Eastern and Western forms of democracy. It has dispelled that. You know, Mr. Lee Kuan Yew championed this notion of Eastern democracy whereby economic rights prevail over human rights. And in fact, if you look deeper into the arguments, it is at the expense of human rights. And this was, in fact, Singapore became the PR company for PRC, PRC for PRC. You know? When China found it very convenient that it has Singapore as its PR channel to perpetuate its authoritarian practices. In fact, we saw during the Tiananmen disaster that Lee Kuan Yew was saying that he will do the same thing. Exact words were that he will be prepared to shoot 200,000 students or 200,000 protesters to preserve political order in the country. Juxtapose this with the 250,000 people who demonstrated during the Bersih movement. Can you imagine? Even Najib did not take this advice from Lee Kuan Yew. And that shows the fundamental right of freedom of assembly. When the government is corrupted, when a government is corrupted, people have less choice. What the Malaysians have understood is that what may be legal may not be just. As in, protesting may be illegal. But what may be legal may not be just, and what may not be just, you know. So that is extremely crucial for us to learn that whilst Mr. Tan Kin Lian was making this comment that even one-man protest is not allowed in Singapore, and in fact we give new meaning to one-man protest as being unlawful assembly. In fact, it defies Oxford meaning of assembly, you know. And finally, I would like to address this issue that the Malaysian elections have seen several oppressive laws that we also have in Singapore under review or in the prospect of being amended or repealed. They are the internal security, they have the national security laws, we have the Internal Security Act that's going to go off, then we have the mandatory death sentence in Singapore, and Malaysia is completely abolishing a mandatory death sentence. In fact, Singapore, we just have partial discretion for the judges in death penalty cases, but in Malaysia, they are fully going to give the discretion to the judges, and also it is in the DAP's manifesto that the death penalty should be completely abolished, and I believe that that momentum will be also taking place in Malaysia. The next, of course, we all talked about the fake news bill, and that bill is going to be withdrawn. Now, when I look at all this legislation, when I look at the previous politicians in Malaysia, the arrogance in which they have displayed. Now we see that in our ministers as well. You saw the fake committee, not the select committee. Sorry, that was a Freudian slip. Online falsehoods. Guess this video is going online, you know. So anyway, we saw the kind of arrogance displayed by the leaders on the select committee hearing. The law minister was humiliating PJ Tam. In fact, he was rather intimidating PJ Tam, and the chairman of the select committee was humiliating PJ Tam with questioning his credentials and so on and so forth. Now, when I look at all this display of arrogance, and these legislations also emanate from that arrogance without a proper contestation of ideas from the people. Now, I have a Shakespearean quote to describe them. Usually I don't cite Shakespeare in my public speeches, though I like Shakespeare very much. Man, but proud man, dressed in a little brief authority, plays such fantastic tricks before high heaven as make the angels weep. And I just hope that our people can pluck up the courage, like our Malaysian brothers and sisters, and through the force of ballot, bring, or rather regain, our soul and heart of this nation again. And I hope that we will also be a first world democracy with the democratic rights that are similarly restored in Malaysia. Thank you.